In this case, the defendant was convicted of aggravated rape of his 8-year-old stepdaughter and was sentenced to death under Louisiana law. In Louisiana, there was a state statute which authorized capital punishment for the rape of a child under 12, regardless of the fact that no murder of the victim was committed at the time of the rape. The defendant appealed his death sentence on the basis it violated his Eighth Amendment rights against cruel and unusual punishment. The Supreme Court of Louisiana affirmed the defendant's conviction, and thus, the defendant appealed to the U.S. Supreme Court. How would you decide this case? Did the sentence of death of the defendant under Louisiana law for raping a child under 12 constitute cruel and unusual punishment in violation of the U.S. Constitution? We'll be back in a moment with the answer to that question. Did the sentence of death of a defendant who was convicted of aggravated rape of his 8-year-old stepdaughter constitute cruel and unusual punishment in violation of the defendant's Eighth Amendment rights under the U.S. Constitution? Yes, according to the U.S. Supreme Court. In reversing the Louisiana court, the Supreme Court held that although the aggravated rape of the child constituted a moral depravity, imposition of the death penalty was disproportionate to the crime itself, where the crime did not result in the victim's death. This case is about the imposition of the death penalty where there is no homicide during the commission of the felony rape of a child. The constitutional prohibition against excessive or cruel and unusual punishment mandates that punishment be exercised within the limits of civilized standards. The Supreme Court concluded that there is a distinction between intentional first-degree murder on the one hand and a non-homicide crime on the other. To impose the same penalty for child rape as for a homicide was cruel and unusual punishment in violation of the defendant's Eighth Amendment rights under the U.S. Constitution. The court went on to say, in effect, by making punishment of child rape equivalent to the punishment for murder, that is, the application of the death penalty, a state may remove a strong incentive for the rapist not to kill his victim. Thus, rather than a deterrent, if a perpetrator of child rape is going to be sentenced to the death penalty, regardless of whether he kills the child, the death penalty has no deterrence, but in fact may have the opposite impact of a perpetrator killing a child after rape to silence the child as a witness to avoid the death penalty. Remember, it's a matter of law.